Good morning. My name is Erwin Chemerinsky. I have the great pleasure of being the Dean of Berkeley Law, and it's wonderful to talk with you about the United States Supreme Court's just completed term. In January of this year, as you may know, Justice Sonia Sotomayor came and spoke at Berkeley Law. It was structured that I was interviewing her. And I began by saying, so much has happened in the Supreme Court in the last 2 years. There's so much on the docket for this term. How are you? She responded by saying, I'm exhausted. And it's easy to see why. This was another monumental term in the Supreme Court, following monumental terms the last 2 years. The Supreme Court decided 59 cases with signed opinions after briefing and oral argument. This seems the new normal in terms of the number of cases being decided. The year before it was 58. The year before that it was 58. The year before that it was 54. The year before that it was 52, the smallest number to be decided in a year since 1862. In the 1980s, the Supreme Court was deciding over 160 cases a year. In William Rehnquist's last term as chief, October term 2004, the court decided 85 cases. Now it seems to be in the high 50s each year. If I had a theme about this term of the court, I would say it's a court divided. This is reflected in many things. The court this term, out of 59 decisions, had 23 6-3 decisions, another 5 5-4 decisions. Of the 23 6-3 divisions, the most familiar split among the justices was ideological, with a majority of Roberts, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, and a dissent of Sotomayor, Kagan, and Jackson. But there were also notable 6-3 decisions where the three dissenters were Thomas, Alito, and Gorsuch. They have emerged the most conservative bloc on a conservative court. But even in the cases that were unanimous or near unanimous, we saw divisions among the justices. We're going to talk later about an important Second Amendment case, United States versus Rahimi. It was an 8-1 decision, but 7 justices wrote opinions sharply disagreeing with another. I'm going to talk about an abortion case in a few minutes, Moyle versus United States, that the Supreme Court dismissed without a decision. But there were 4 different opinions written, including real anger expressed in Justice Alito's dissent. In fact, many times over the course of this hour, I'm going to refer to justices writing angry opinions. There are opinions where there's real vitriol expressed. So if I had to describe this court, I'd go back to what was said about an earlier Supreme Court. In the late 1940s, someone referred to the Supreme Court with Justices Jackson and Black and Douglas and Frankfurter, really loathed one another, and called them like scorpions in a bottle. If I had to describe the current Supreme Court, I'd say there are 9 angry scorpions in a bottle. Well, what I want to do, as I've done in past years, is review for you what I regard as the most important decisions of the term for the law, for our society. Prepared a handout, and it's available to you in the chat, that lists the cases in the order in which I'll be talking about them. Obviously, in an hour, can't cover all of the cases, but I'll save some time at the end for questions. Please put your questions in the Q&A, and my terrific assistant, Whitney Mello, will read some of those questions, and I'll be able to answer them then. And obviously, they can include cases that I didn't get to that you might want to talk about. I was trying to think about what's the best way to organize the material, and ultimately I concluded I'm just going to go alphabetical by topic. So the first topic in the handout then is abortion. As you know, 2 years ago, on June 24th, 2022, in Dobbs versus Jackson Women's Health Organization, the Supreme Court overruled Roe versus Wade. This term, for the first time since Dobbs, the Supreme Court had 2 cases with regard to abortion. Neither, of course, involved whether there's a constitutional right to abortion. That was resolved in Dobbs. But both had the potential to be enormously important as to the availability of abortion in the United States. The first of the cases is Food and Drug Administration versus Alliance for Hippocratic Medicine. In the year 2000, the FDA approved a two-drug protocol for medically induced abortions. According to the Guttmacher Institute, last year, 63% of all the abortions in the United States were medically induced rather than surgically performed. One of the drugs in this two-drug protocol is mifepristone. The Alliance Defending Freedom, a conservative organization, through an offshoot, the Alliance for Hippocratic Medicine, filed a lawsuit challenging the FDA's approval of mifepristone and also challenging regulations that made it more easily available. They filed their lawsuit in the Amarillo Division of the United States District Court of the Northern District of Texas. I mention this because there's only one judge in the Amarillo Division of the United States District Court for the Northern District of Texas, Judge Matthew Kaczmarek. So any case filed in that division goes to him. The Alliance Defending Freedom didn't choose this division, this judge, accidentally. Kaczmarek had been an outspoken opponent of abortion rights before President Trump nominated him for the federal bench. Judge Kaczmarek did not disappoint the Alliance Defending Freedom. He wrote a stunning opinion saying he won't refer to it as an embryo or fetus. It's the unborn child, the unborn human being. He said that the unborn human being has constitutional rights from the moment of conception. He said the FDA's approval of mifepristone violated the Administrative Procedures Act as being arbitrary, capricious, and an abuse of discretion. The United States Court of Appeals for the Fifth Circuit in part reversed and in part affirmed. The Fifth Circuit said that the FDA's approval of mifepristone in 2000 is too long ago to now be challenged. But, the Fifth Circuit said, the FDA's more recent rules, making mifepristone more easily available, violated the Administrative Procedures Act. In 2017, the FDA changed the rules to say that no longer would there have to be 3 doctor's visits before getting mifepristone. Only 1 doctor's visit was required. And then in 2021, the FDA said no doctor's office visits are required. For no other drug on the market was there ever a requirement of actually physically going to a doctor's office. The FDA changed and lowered the dosage required for mifepristone. It used to be that mifepristone could be used only in the first 6 weeks of pregnancy. The FDA changed it the first 10 weeks of pregnancy. The FDA said that nurse practitioners could prescribe mifepristone. The Fifth Circuit said that all of that was arbitrary, capricious, and an abuse of discretion. Had the Supreme Court affirmed the Fifth Circuit, it would have greatly restricted the availability of mifepristone. The Supreme Court unanimously reversed. Justice Kavanaugh wrote the opinion for the court. The court said no one had standing. No one could show that they were injured by the greater availability of mifepristone. The Alliance Defending Freedom's theory was, and this was expressed at oral argument, that if a pregnant person took mifepristone and the abortion was incomplete, that individual would then go to an emergency room. A doctor there would have to complete the abortion, and it could be a doctor who had a conscience or religious objection to abortion. In oral argument, several of the justices asked the attorney for Alliance Defending Freedom, Aaron Hawley, can you show a single instance where that's ever happened? And Attorney Hawley could not. Justice Kavanaugh said, therefore, no one can show an injury sufficient for standing. Justice Kavanaugh also mentioned there is a federal law that says no doctor who opposes abortion on conscience grounds should ever have to perform one. This, for now, keeps mifepristone more readily available under the new FDA rules. But you should know there's another lawsuit pending brought by 2 state governments challenging mifepristone, and there's likely other legal actions in the works. So one cannot be sanguine and say that the issue is permanently resolved. It's just that the court dismissed the case on standing grounds. The other abortion case, Moyle versus United States, was dismissed entirely. It involves a federal statute, the Emergency Medical Treatment and Labor Act. It says that if a pregnant woman goes to an emergency room, the emergency room must provide the medical treatment necessary to stabilize her health. The Biden administration has adopted rules that say that if the health of the pregnant woman called for an abortion, and she wanted an abortion, one has to be provided. And it might be that protecting her future reproductive health would require the performance of an abortion. Idaho has adopted a law that prohibits abortions except if necessary to save the life of the pregnant person. A federal district court in Idaho issued a preliminary injunction. The judge said, federal law requires an abortion be performed to protect the health of the pregnant individual, whereas Idaho allows abortion only to save the life of the pregnant person, that Idaho law is preempted in circumstances where federal law would warrant an abortion. Idaho went to the Ninth Circuit for a stay of the preliminary injunction. The Ninth Circuit denied the stay. Idaho went to the Supreme Court on its emergency docket, its shadow docket, to request a preliminary injunction be stayed. The Supreme Court did something unusual. It granted certiorari, it scheduled briefing and oral argument on the case. And then, to the surprise of most, the Supreme Court dismissed the case as certiorari improvidently granted. The case is sent back to the Ninth Circuit. But as I alluded to in my introduction, there were 4 different opinions. Justice Kagan wrote an opinion, joined by Justice Soter and Jackson, in which she indicated that she believes that the Idaho law is preempted in circumstances where federal law would require an abortion to protect the health of the woman. Justice Jackson wrote a dissent saying she believes the Supreme Court should decide the issue now and find preemption, resolve any uncertainty. Justice Alito wrote an angry dissent, joined by Justice Thomas and Gorsuch, saying the Supreme Court should resolve the issue now and make clear that the Idaho law is not preempted. Justice Alito wrote a strong anti-abortion opinion. You might have seen that Linda Greenhouse wrote an opinion in the New York Times, an op-ed piece in the New York Times about it, where she referred to Justice Alito's opinion, and I quote, as unhinged, certainly reflects the vitriol in the opinion. And Justice Barrett wrote a concurring opinion, joined by Chief Justice Roberts and Justice Kavanaugh, saying, we never should have taken this case before the Ninth Circuit had the opportunity to consider it. We sent it back to the Ninth Circuit. There are a lot of cases pending in federal courts around the country involving EMTALA and state laws that prohibit all or almost all abortions. All we know at this point is 3 justices will find preemption, 3 will reject preemption, and 3 haven't said yet. The second area on the handout is administrative law. And I have no doubt that when historians look back at the Roberts Court, they will say that among its most significant changes in the law with regard to the administrative state. Each of the prior 2 terms, the Supreme Court created and applied a new doctrine limiting administrative agencies, the major questions doctrine. The major questions doctrine says, if it's a major question of economic or political significance, an administrative agency can act only if there's clear direction from Congress. The Supreme Court hasn't yet clarified what's a major question of economic or political significance. What's enough direction from Congress? And thus there are dozens and dozens of lawsuits challenging agency actions pending now under the major questions doctrine. This term, I want to talk about 2 major cases that change administrative law. The first is Loper Bright Enterprises versus Raimondo. In 1984, in Chevron USA versus Natural Resource Defense Council, the Supreme Court said, if a federal statute is ambiguous, courts should defer to an agency interpretation of the statute so long as the agency is being reasonable. That case involved the Clean Air Act. The Clean Air Act empowers the Environmental Protection Agency to adopt rules. Imagine the EPA adopts a rule about how much of a particular pollutant can be put in the air. Chevron deference would say courts should defer to the agency so long as it's reasonable. The Supreme Court ultimately developed a two-step approach. First, the court has to decide, is the statute ambiguous? If not, the statute is followed. And if it is ambiguous, then second, is the agency action reasonable? In Loper Bright Enterprises versus Raimondo, the Supreme Court expressly overruled Chevron and ended Chevron deference. Chief Justice Roberts wrote the opinion for the court. Justice Kagan wrote the blistering dissent, joined by Justices Sotomayor and Jackson. Chief Justice Roberts began by invoking Marbury versus Madison. He said it's the province and duty of the judicial department to say what the law is. It's for courts to interpret statutes. He said there is no reason for the judiciary to give any deference to agencies when they interpret statutes. Justice Kagan objected to the overruling of precedent. She invoked stare decisis. So there's no reason to overrule Chevron deference other than a current majority doesn't like it. She talked about the need to have deference to the expertise of agencies. So that's what Chevron deference is all about. She regarded this as an enormous change with regard to the structure of government and how administrative agencies are to proceed. What's it going to mean? Well, practically speaking, I think we're going to see far more challenges to agency actions in federal courts. Lawyers now know the courts don't have to defer to the agencies. Courts are more likely to overrule the agencies unless there's every reason to bring a challenge. And I think we're going to see many more agency actions overturned. I think it's a significant shift of authority from agencies to the federal courts. The other case I want to talk about here is Securities and Exchange Commission versus Cherkessy. I regard it as one of the sleeper cases of the term. It didn't get that much media attention, but it's again a case that's going to have a real practical effect if you're a lawyer. It involves the Securities and Exchange Commission bringing a fraud proceeding against George Cherkessy and his company. The Securities and Exchange Commission brought it before an administrative law judge in the SEC. The administrative law judge found against Cherkessy and his company, and the Securities and Exchange Commission affirmed this. They imposed a $300,000 civil penalty against Cherkessy and the company, as well as other sanctions limiting their ability to be involved in the securities business. The United States Court of Appeals for the Fifth Circuit overturned the SEC decision on a number of grounds. The Supreme Court, in a 6-3 decision, affirmed on one of those grounds. Here, Chief Justice Roberts again wrote for the court. Justice Sonia Sotomayor wrote a vehement dissent. Chief Justice Roberts said, to allow an agency through an administrative proceeding to impose a civil penalty for fraud violates the Seventh Amendment right to jury trial in civil cases. He said that the agency, if it wants a civil penalty, must go to federal court where a jury trial under the Seventh Amendment is available. Justice Sotomayor in her dissent said, never before has the Supreme Court held that agencies can't impose civil penalties. She said there are dozens of agencies under hundreds of statutes that do this. She said, in fact, in the past, the Supreme Court has said there are public rights matters, disputes between the government and individual, that Congress can assign to an agency. Well, what's this going to mean in practice? To start with, there are many questions that this case leaves open. Is this just about civil penalties for fraud? Or does it say that agencies never can impose civil penalties? What about agencies that have statutory authority to impose civil penalties, but don't have the statutory authority to go to court? Justice Sotomayor mentions the Occupational Safety and Health Administration. It can impose civil penalties and fines, but it doesn't have the ability to go to court under the statute. Does this mean that the Occupational Safety and Health Administration regulations can't be enforced at all? Will the courts infer an ability to go to court? What's left of the public rights doctrine that previously had said that Congress could assign to agencies civil disputes between the United States and individuals? What about federal statutes, and there are some that create mandatory arbitration where the arbiter can impose a monetary fine penalty. If an agency can't do this because of the Seventh Amendment, then can an arbiter do this? Again, I think what this case means is a significant shift in authority from the agencies to the courts. And I think it's going to mean a substantial increase in matters being brought to the federal court where agencies want penalties. The third area I list is criminal law. And one of the things that's interesting is that while the overall Supreme Court docket has gone down greatly, the percentage of criminal law and procedure cases has gone down even more precipitously. It's interesting to speculate as to why. One reason I think is a statistic that's little noted. This past term, out of 59 cases, only 4 were reviewing state court decisions. All the rest were reviewing federal court appeals decisions. Most criminal cases arise in state court. If the Supreme Court's not reviewing state court decisions, then there's just less occasion for having criminal procedure decisions being handed down by the Supreme Court. This isn't a one-year phenomenon. A year ago, the court decided only 5 cases reviewing state courts. The year before that, only 5 decisions reviewing state courts. The year before that, only 3 were reviewing state courts. Also, there aren't any new federal criminal statutes. Usually when there are, it's an occasion necessitating Supreme Court review. There was one major criminal law case I want to talk about this term. It involved the Eighth Amendment, and it's going to have real practical effect, especially here in California. The case is City of Grants Pass versus Johnson. In 2018, in Martin versus City of Boise, the United States Court of Appeals for the Ninth Circuit said it violates the Eighth Amendment as cruel and unusual punishment to criminally punish an unhoused person for sleeping in public if there aren't adequate shelter beds. Judge Marcia Brazan wrote the opinion for the Ninth Circuit. She pointed to a 1962 case, Robinson versus California, where the Supreme Court said that the government can't punish status. There, the court said, the government couldn't punish somebody for being a drug addict. Judge Brazan said, everyone has to sleep, and the government can't punish somebody criminally for sleeping in public if there aren't adequate alternatives, shelter beds. City of Grants Pass versus Johnson applied Martin versus City of Boise. Grants Pass is a city in southern Oregon. It has an unhoused population greater than the number of shelter beds. It adopted 5 ordinances that ultimately make it a crime to sleep in public and include making it a crime for someone to have a blanket, cardboard, or a pillow to sleep in public. Judge Rosalind Silver, a district court judge sitting by designation, wrote the opinion for the Ninth Circuit declaring the Grants Pass ordinance unconstitutional. The Supreme Court, in a 6-3 decision, reversed. Here, Justice Gorsuch wrote for the majority, and Justice Sotomayor wrote an impassioned dissent, joined by Justices Kagan and Jackson. Justice Gorsuch said, the Eighth Amendment is about the type of punishment the government can impose and the length of the punishment. It's not about what crimes can be punished. This is a significant change in the law. The court didn't expressly overrule Robinson versus California, but it, and other cases like Ingram versus Wright, had previously said the Eighth Amendment limits what conduct can be punished. Justice Gorsuch, writing for the court, said that a city can apply its anti-camping ordinance against unhoused individuals, even if there are not adequate shelter beds, even if there's nowhere else for them to go. At the end of his opinion, Justice Gorsuch said, the problem of homelessness in the United States is an enormously difficult one. It's not for the court to solve. We leave this to local governments. Justice Sotomayor's dissent echoed what the Ninth Circuit had said. Justice Sotomayor said, sleep is a biological necessity. People have to sleep in public unless there's adequate shelter beds. Justice Sotomayor said that the cruelty of the majority opinion is the message. If you're homeless, either stay awake or be arrested. In practical effect, what this means is that local governments can use their criminal laws against the unhoused. I think how they choose to do that is going to vary enormously across cities in California and in the country. And there are going to be many other legal issues. I think there's going to be Fourth Amendment issues in terms of if an unhoused person is arrested, what happens to his or her possessions? When is it an impermissible search, seizure of somebody's goods? I think there are going to be issues that are raised still with regard to the Eighth Amendment in circumstances. Perhaps how can those who are mentally ill be treated by the government? But it is a case that will mean a significant shift in cities throughout California and cities throughout the country. I can't help in reading this decision and thinking about it to not reflect on the words of Anatole France, who said, "The law in its majestic equality protects equally the right of the rich and the poor to sleep under bridges and beg in the streets." The fourth area that I want to talk about concerns the First Amendment. I and other commentators expected that this was going to be a big term in the Supreme Court with regard to the First Amendment. There were especially a number of cases involving the internet and social media. But what's striking is that the Supreme Court either didn't decide them or ruled narrowly. There were three major First Amendment issues before the court this term. The first of these involves if a government official has a social media account and discusses government business on it, does it violate the First Amendment for the government official to block critics from having access? You might remember an issue that arose concerning a former president who was frequently on Twitter, but blocked his critics from having access to Twitter. A lawsuit was brought against President Trump. Both the district court and the Second Circuit ruled against him. When it got to the Supreme Court, he was no longer president, so the case was dismissed as moot. Linke versus Freed involves James Freed, who was the town manager of Port Huron, Michigan. He had a social media account. We posted family pictures, discussed family events, but he also discussed government business. Kevin Linke was a constituent in Port Huron, Michigan. He posted critical messages about Freed, especially how Freed was responding to COVID. And also, he posted critical messages about other aspects of the government's actions. Freed took down Linke's critical messages, and Freed blocked Linke from continuing to have access. Linke sued. The United States Court of Appeals for the Sixth Circuit ruled in favor of James Freed. The Sixth Circuit said, this is his social media account. There's no state action. The First Amendment doesn't apply. The United States Supreme Court reversed. Justice Barrett wrote the opinion for the court. It was unanimous. Justice Barrett said, in deciding this issue, courts should use a two-step inquiry. First, the court has to decide, did the individual have the authority to speak for the government? And if so, second, was the individual purporting to speak for the government? I know that lawyers and judges love two-part tests, three-part tests. And yet I'd suggest this is a test that doesn't give very much guidance to the lower courts when these situations arise. Think of the first question. Did the person have the authority to speak for the government? How is that to be determined? I'm the dean of UC Berkeley Law School. When do I have the authority to speak for the law school? Maybe never. One could say that legally, only the regents of the University of California have the authority to speak for the University of California. Or maybe you could say that only the chancellor has the legal authority to speak for the campus. And then second, how is decided if somebody is purporting to speak for the government? I write a lot of op-ed pieces. Every op-ed includes a byline that says, I'm Dean UC Berkeley School of Law. Does that mean I'm purporting to speak for the government? How is that to be determined? I would note at the end of her majority opinion, Justice Barrett says that there might be significance under the First Amendment between taking down critical posts and blocking someone from having access. She said blocking is much more likely to violate the First Amendment, and that could be important in the future. The second issue that was before the court this term involves the question, when is speech by government officials, by itself, without sanctions being forced, a violation of the free speech rights of others? Let me make this concrete. At the beginning of each school year, I send a message to the students, encourage them to speak respectfully to one another, to exercise civility, to not engage in hateful expression. Last year, some students came to me and said they objected to my message that I was chilling their speech. If I condemn speech as anti-Semitic or Islamophobic or racist, with no sanctions being imposed on the students, can it be said that I'm violating their speech by chilling their expression? There were two cases on the docket this term that raised this issue. The first of these cases was National Rifle Association versus Vullo. Maria Vullo was an insurance business commissioner in New York. After the tragic Parkland, Florida shooting, where 17 people got killed, she went to insurance companies and banks and encouraged them not to do business with the National Rifle Association. The National Rifle Association sued Vullo. The United States Court of Appeals for the Second Circuit ruled in favor of Vullo. The Second Circuit said Vullo was just engaging in speech. Indeed, she too has First Amendment rights. The United States Supreme Court unanimously reversed the Second Circuit. Justice Sotomayor wrote the opinion for the court. Justice Sotomayor invoked a 1963 decision, Bantam Books versus Sullivan. That case involved a Rhode Island Commission on Decency and Morality. The commission identified books that it found to be objectionable, and it said that booksellers who sold those books could face criminal prosecution. The police went to some of the booksellers and said, "You're selling offensive books, you could be arrested and prosecuted." The Supreme Court found that that violated the First Amendment. Justice Brennan said, even though no one had actually been prosecuted, that kind of government coercion was unconstitutional. Justice Sotomayor applied this in the Vullo case. She said, Maria Vullo told insurance companies and banks that they had violated state regulations and that they could be prosecuted for doing so, but that they wouldn't be if they stopped doing business with the National Rifle Association. The court said, we have to accept the allegations that the complaint is true, since on a motion to dismiss. And she said, under Bantam Books versus Sullivan, that kind of threat is enough to violate the First Amendment. And the court then sent the case back to go forward. The court was clear at the end of the opinion. It's not extending Bantam Books versus Sullivan, but it's saying if government officials threaten punishment, then that's enough to be coercion under the First Amendment. The other case on this topic was Murthy versus Missouri. This was a lawsuit by 2 state governments and 5 social media users that said that the Biden administration had violated the First Amendment by pressuring social media companies to take down false speech. The false speech at issue here involved the COVID vaccine and also the 2020 election. A federal district court judge in Mississippi issued a broad injunction finding that the pressure from the Biden administration violated the First Amendment. The Fifth Circuit affirmed, though dismissed some of the agencies, but the injunction was going to be against the White House, the FBI, the Center for Disease Control, keeping them from communicating with social media platforms. What exactly did the Biden administration do? It told the social media companies that if they didn't take down false speech, they would face more government regulation in the future. This seems quite different from a threat of prosecution. The Supreme Court, in a 6-3 decision, dismissed this case on standing grounds. Justice Barrett wrote the opinion for the court. She said, in order for there to be standing to sue in federal court, the plaintiff has to show that it has been injured or imminently will be injured, that the injury was caused by the defendant, and that a favorable court decision will remedy the injury. Justice Barrett said social media platforms are private entities. They get to make the choice about what's on their platform or not. Justice Barrett said that the plaintiffs did not allege and could not show that it was the Biden administration that caused the choices with regard to this, and that therefore there wasn't standing to sue. Justice Alito wrote a very angry opinion, joined by Justice Thomas and Gorsuch. He said, I think this is the most important free speech case to come to the court in years. He said, if you accept all the allegations of the complaint is true, this is coercion that violates the First Amendment. But the Supreme Court didn't decide the issue, dismissing on standing grounds, and I think making it clear it'd be very hard for someone to have standing to bring such a suit in the future. The third and final area with regard to the First Amendment this term was that which might have been the most important cases, and that's, can state governments prohibit social media platforms from engaging in content moderation? Florida and Texas each adopted laws that prohibited large social media platforms from engaging in content moderation. The laws were somewhat different, but they had the same effect. Social media companies engage in content moderation all the time. Facebook takes down 5,000 hateful messages an hour. Social media platforms are regularly taking down child sexual exploitation material, even if we're protected by the First Amendment. Social media platforms are regularly taking down material that would encourage terrorist activity, even if it was protected by the First Amendment. Florida and Texas believe that social media platforms disproportionately censor conservative speakers and thus adopted the laws. The United States Court of Appeals for the 11th Circuit struck down the Florida law. The United States Court of Appeals for the 5th Circuit upheld the Texas law. The Supreme Court in Moody versus Net Choice did not resolve the issue. Justice Kagan wrote for the court. She said, this is a facial challenge to both the Florida and the Texas laws, an argument that they were on their face unconstitutional. She said, for a facial challenge on the First Amendment, it's necessary to consider all of the unconstitutional applications and see if they outweigh the constitutional applications. She said the 11th Circuit and the 5th Circuit just considered a few social media platforms. They didn't consider the range of social media platforms, so the cases were remanded. But Justice Kagan didn't stop there. She said, we need to give guidance to the lower court. She said, the 5th Circuit was clearly wrong. She said, social media platforms are private entities. They get to decide what speech to allow or what not to have on their platform. She invoked especially a 1974 Supreme Court case, Miami Herald versus Tornillo. It involved a Florida right to reply statute. The Florida law said that if somebody was verbally attacked in a newspaper, they had the right to reply in that newspaper. The Supreme Court unanimously struck that down, saying, newspapers are private entities. They get to decide what to publish or what not to publish. Justice Kagan made clear that that gives to social media platforms the First Amendment right to decide what to include or not include. I think that it gives a clear indication that the Florida law and Texas laws are going to be declared unconstitutional. Justice Alito again wrote a very angry dissent. He said the Supreme Court said it wasn't deciding the issue, but then it went on to do so. And he disagreed. And he said he doesn't believe that traditional First Amendment principles should be applied to the new media like the internet and social media. So the issue remains open. It will continue to be litigated, but there is some guidance from the Supreme Court. The fifth area that I list concerns the Second Amendment. From 1791, when the Second Amendment was ratified, until 2008, not one federal, state, or local gun regulation was struck down by the Supreme Court. In the handful of Supreme Court cases dealing with the Second Amendment, the Supreme Court always said the Second Amendment means what it says. It's right to have guns in the home for militia service. But in June of 2008, in District of Columbia versus Heller, the Supreme Court said the Second Amendment protects the right of people to have handguns in their home for the sake of security. It was a 5-4 decision, split along ideological lines. The court did not prescribe a standard or a level of scrutiny to be used in evaluating gun regulations. The court did not return to the scope of the Second Amendment for 14 years until on June 23rd, 2022, in Bruin, the National New York Rifle and Pistol Association versus Bruin, the court struck down a New York law that said that a person could have a gun in public only if there's a permit. Get a permit, someone would have to show cause, a safety need. The court said the Second Amendment protects the right to have guns in public, but Justice Thomas's majority opinion, it was 6-3, said that the only gun regulations that should be allowed are those that are historically permitted. For all other constitutional rights, for equal protection, the government can act, at least if it meets strict scrutiny, if it's necessary to achieve a compelling purpose. But the Supreme Court in Bruin explicitly said that it's not going to look to whether the government action is serving a compelling need, not look to whether the government action is necessary. The court's going to focus only on history and tradition. 3 times, Justice Thomas said, the Second Amendment is an unqualified right. Bruin has led to an enormous amount of litigation, hundreds of decisions in the last 2 years, clarifying how to determine what history and tradition allows in terms of the Second Amendment. United States versus Rahimi is the first case to come to the Supreme Court involving the Second Amendment since Bruin. It involves a federal law that makes it a federal crime for a person under restraining order in a domestic violence case from having a gun. Zaki Rahimi was seen seriously abusing his girlfriend in a parking lot. When someone came to help her, he fired his gun. She went to Texas State Trial Court. She got restraining order against him from having contact with her or her family for 2 years. The judge in issuing the restraining order said to Rahimi, under federal law now, you're not allowed to have a gun while the restraining order is in effect. Rahimi was then a suspect in many other gun shootings. Police got a search warrant and went to his home. When they executed the search warrant, they found a large number of guns, and with the guns, they found the judge's order that he wasn't allowed to have them. He got prosecuted in federal court. He challenged the constitutionality of the statute. He lost. He then pled guilty and did an appeal to the Fifth Circuit. The United States Court of Appeals for the Fifth Circuit ruled in his favor. The Fifth Circuit said in 1791, there weren't laws that kept people under restraining orders in domestic violence cases from having guns. Therefore, this law is unconstitutional. Of course, tragically, in 1791, there weren't laws against domestic violence. There weren't restraining orders in domestic violence cases. The Supreme Court, in an 8-1 decision, reversed. Chief Justice Roberts wrote for the majority. There were many separate concurring opinions, and then there was a dissent by Justice Thomas. There were 7 opinions altogether. Chief Justice Roberts said, we held in Bruin that we determine what gun regulations are permissible by looking at history and tradition. He said, but the Second Amendment, I'll quote him, is not frozen in amber. He said, there doesn't have to be the particular kind of law in 1791 to allow a law today. He said in 1791, there were laws that kept people who were adjudicated by a court to be dangerous having guns. He said that's a close enough analogy. Justice Gorsuch said we should be focused just on what was the law in 1791, but he felt that under that law, the regulation would be allowed. Justice Barrett and Kavanaugh agreed with Chief Justice Roberts that it should be a historical approach, and there were sufficient analogs in 1791. Justices Sotomayor and Jackson wrote concurring opinions saying, we were wrong in Bruin. We shouldn't just be focusing on history. They said that the federal law at issue had saved so many lives and so many women's lives, and that's why it should be allowed today, not because whether there was an analog in 1791. Justice Thomas dissented and would have declared it unconstitutional. So what does it mean if you as a lawyer involved in gun rights litigation? The Supreme Court adheres to an originalist historic approach to the Second Amendment. I think this case makes it likely that laws that keep those who've been adjudicated to be dangerous from having guns are constitutional. There's a federal law and many state laws that keep those convicted of felonies from having possession of guns. I think those laws are likely to be upheld. It's harder to read anything into this case as to how the court's going to deal with things like prohibiting particularly dangerous weapons like AR-15s or large capacity ammunition magazines. Hard to find anything in this case about restrictions on where people can have guns. But I do think this gives the government the ability to keep those who've been adjudicated in some ways dangerous from having guns. The sixth and final area that I would list, I'll just call the Donald Trump docket in the Supreme Court. There were two cases. The first is Trump versus Anderson. It involves Section 3 of the 14th Amendment. Section 3 says that if a person took an oath to uphold the Constitution and then participates in a rebellion or insurrection, they're not allowed to be a senator or representative, a candidate for president or vice president, or hold any civil or military office. As you know, in December of 2023, the Colorado Supreme Court, in a 4-3 decision, found that Donald Trump was disqualified from being on the ballot for president in Colorado, Republican primary, because of Section 3 of the 14th Amendment. The United States Supreme Court unanimously reversed, but there were still a number of opinions. There was a per curiam opinion, an opinion of the court for the majority. It gave two reasons. First, it said, it's not for state courts to enforce Section 3 of the 14th Amendment. It has to be for federal courts. They said that if we let state courts enforce the 14th Amendment, there could be a patchwork where somebody could be a candidate in one state, but not others. And second, they said, it takes specific federal law to enforce Section 3 of the 14th Amendment. In technical terms, it's not self-executing. Justices Sotomayor, Kagan, and Jackson wrote an opinion concurring in the judgment that very much had the tone of a dissent. They said the first ground is sufficient, no reason to go to the second ground. Justice Barrett wrote an opinion concurring, and she chastised those three justices for their opinion. She didn't do so by name, but by clear implication. She said, especially in these tense times and controversial cases, we should lower the rhetoric, lower our voices, not promote more division. After the case was argued on February 8th, I think there was no doubt as to what the Supreme Court was going to decide. As a result, I don't think the court's reasoning has gotten the attention it should. Take the first ground. It's not for state courts to enforce Section 3 of the 14th Amendment. Why not? State courts enforce the 14th Amendment every day. In every criminal case where there's a suppression motion, it's the Fourth Amendment is applied to the states of the 14th Amendment that's being enforced. If a state were to adopt a discriminatory law, it would get challenged in state court as violating equal protection. Surely the state court would enforce the 14th Amendment. Why not Section 3? Well, there's the argument that if we allowed states to enforce Section 3, someone might be just qualified in one state, but not another. The flaw in this argument is ultimately the case would go to the Supreme Court and be the Supreme Court that would decide for the whole country whether or not the person was disqualified. The case would arise in a state. All cases arise in a state, in either state court or federal court, but ultimately go to the Supreme Court, and it would be the Supreme Court that would decide for the whole country whether Section 3 is met. The second ground is it takes a statute to enforce this. Why? There are other disqualifications on to be president. You have to be 35 years old, a natural-born citizen, not having served already 2 terms as president. Those don't take a statute. Also, Congress said in 1883 that the 14th Amendment is self-executing, and it doesn't require a statute. Even more important, the last sentence of Section 3 says Congress can remove this disability by 2/3 vote of both houses of Congress. Doesn't that specify what Congress's role would be? I think the effect of this case is to read Section 3 of the 14th Amendment out of the Constitution. The other case is Trump versus the United States, decided Monday, July 1st. As you know, Special Counsel Jack Smith indicted Donald Trump in the United States District Court for the District of Columbia. The indictment covered many matters. It involved his attempting to use the Justice Department to subvert the outcome of the 2020 election. It involved his trying to persuade Mike Pence to throw the election to him in Congress on January 6th. It involved Donald Trump going to state election officials, try to get them to give him more votes in their states so he would get their electoral votes. It involved Donald Trump's involvement for the insurrection on January 6th. Trump moved to dismiss based on absolute immunity from criminal prosecution for anything done while in office. The district court ruled against Trump. The DC Circuit ruled against Trump. But the United States Supreme Court, to a very large extent, ruled in favor of Donald Trump. Chief Justice Roberts wrote the opinion for the court. He said that under the Constitution, the president is the only person who is by himself a branch of government. He said the Constitution was meant to protect the ability of the president to act vigorously and without being chilled by fear of prosecution. Chief Justice Roberts' opinion divided the president's actions into three categories. There's where the president is carrying out constitutional or statutory powers. If there's an official act of the president doing something authorized by the Constitution or statute, the president is absolutely immune from criminal prosecution. In fact, the court said it doesn't matter what the motive of the president is, there can't be prosecution. The court said nothing done in this zone can be used as evidence against the president in any prosecution. Second, the court says there's the zone that are, quote, at the outer perimeters of presidential power. And the court said here, the president has a presumption of absolute immunity. The presumption be overcome. And third, the court said there are private acts of the president, not carrying out the powers of the office, not even at the outer perimeters, and for that, there's no immunity. Justices Sotomayor and Jackson wrote blistering dissents. Justice Sotomayor said, what this means is that the president could use the military to assassinate a political rival, and so the president is acting as commander-in-chief, absolute immunity. Or the president could use the Justice Department for political retribution, and since that's part of the powers of the president, you can't look at the motives, absolute immunity. Or the president could take bribes for issuing pardons or making appointments, and absolute immunity. She included that sentence by saying immune, immune, immune. She said, this subverts the rule of law. The core of the rule of law is that no one, not even a president or former president, is above the law. But this, in essence, makes the president above the law. Usually, justices conclude their dissents by saying, I respectfully dissent. Justice Sotomayor concluded her dissent by saying, with fear for our democracy, I dissent. Justice Jackson also wrote a vehement dissent. I found particularly interesting one footnote that I think powerfully illustrates what this case is about. She said, no one questions that the president can fire the attorney general. The issue here is, can the president assassinate the attorney general? This case says, so long as the president is acting as commander-in-chief, or so long as the president is issuing pardons, so long as the president making appointments or exercising any other constitutional or statutory power, the president can never be criminally prosecuted, and it doesn't matter what the motive of the president is. And the president's acts can't even be used as evidence for liability for things outside of this zone. It is a stunning decision of the Supreme Court, truly one unprecedented in American history. So if you put all of this together, you can see why I say it's such a momentous term in the United States Supreme Court. As promised, I say time for questions. I know we have 5 minutes left. Maybe we can go 10 minutes for questions and get to as many as Whitney can ask.
I'll try to squeeze in as many as I can. So a number of people have written and asked some version of the question, is what this court doing as far as overturning precedent something that's ever happened before? Some people have commented that they've heard that this court is equivalent to the Warren Court as far as overturning cases, but from this court's doing it from the right. Can you share any input on that?
Sure. There's books, long articles written about precedent stare decisis. They always come to the same conclusion. Precedent should be followed except when it should be overruled. And of course, that's right We all believe that precedent has value and stability and predictability in the law. On the other hand, there's times where precedent needs to be overruled. It was imperative that Plessy versus Ferguson overruled Brown versus Board of Education. To answer the specific question, in 1937, the Supreme Court overruled 40 years of precedent that had limited Congress's powers under the Commerce Clause, that had limited what state and local governments could do to protect workers and consumers. I think that was more dramatic than anything seen since. There's no doubt that the Warren Court overruled a number of precedents. When they applied the exclusionary rule of the states, they overruled precedent. When they said that challenges to malapportionment were heard in federal court, they overruled precedent. But there's also no doubt that the Roberts Court now is overruling precedent. Think 2 terms ago of overruling Roe versus Wade, in the Establishment Clause area, overruling Lemon versus Kurtzman. Last year, overruling the affirmative action cases. This year, overruling Chevron deference. And then there are cases where the court's overruled precedent without explicitly saying it's doing so. The bottom line is this court does not give much weight to precedent, but I'm not sure that predecessor Supreme Court have always given much weight to precedent either.
Thank you. Someone asks if you have any thoughts on Biden's coming proposals to reform the Supreme Court.
I agree with him substantively, but I think it doesn't make sense to focus on them now in this election year. They have no chance, realistically, of coming to fruition. What's he proposing? Congress passed an ethics code for Supreme Court justices. I agree. The ethics code that was promulgated by the court itself in November was weaker than that applies to any other judge in the country. Whereas for other judges, it says shall, this says should. There's no mechanism for recusal. It's left to each justice. Sadly, and wrongly, ethics has become a partisan issue. When this was considered in the House Judiciary Committee last summer, the vote was 12-11, exactly along partisan lines. I don't see any chance that the Republican House is going to adopt ethics codes now, because the ethical violations recently have involved Republican conservative justices. Term limits for Supreme Court justices. I strongly favor 18-year non-renewable terms. I've done so for years in print, but I think it would take a constitutional amendment, especially to apply it to currently sitting justices, and there seems no likelihood that you're going to get 2/3 of both houses of Congress and 3/4 of the states. A constitutional amendment to overturn Trump versus United States. Again, given the political valence of the decision, I don't see that happening. I think that what the issue should be now is the importance of the election for the long-term composition of the Supreme Court. In 2016, if Hillary Clinton had won and she had appointed 3 justices rather than Donald Trump, all of the cases that I've referred to would have come out differently. In terms of this election, Clarence Thomas is 76, Samuel Alito is 74. If Donald Trump wins and there's a Republican Senate, I am sure that they will retire so Trump can appoint justice in their late 40s and early 50s and keep these seats in conservative hands for decades to come. Correspondingly, if Kamala Harris wins and there's a Democratic Senate, I expect Sonia Sotomayor to retire. So the future of the Supreme Court is going to be so dramatically affected by this election. And I think that's what we should be talking about in the next few months, not proposals that, however well-intentioned and desirable, have no chance of being adopted.
Great, thank you. A number of people have asked a question basically about originalism and textualism. So I'm just selecting one, but noting a lot of people have asked about this. Do you think that some of the Supreme Court conservative majority opinions during the term have been inconsistent with the textualism and/or originalism approach adopted by the conservative majority in many other cases, such as the presidential immunity opinion?
Absolutely. Focus on the presidential immunity case, Trump versus United States. I'm not an originalist, but from an originalist perspective, anything is clear. It's that the framers of the Constitution wanted to reject royal prerogatives. In England, there's the maxim that the king can do no wrong. That's exactly what the framers of the Constitution rejected. And yet, that's exactly what Trump versus the United States says, that the president, former president, can never be prosecuted for anything using the powers of the office, even for retribution, even if egregious. In terms of the text of the Constitution, The text of the Constitution gives to members of Congress an immunity, the speech and debate clause. There's no such textual provision with regard to the president. And the impeachment clause makes clear that somebody who's impeached, say for bribery, can be criminally prosecuted. And yet this says if a president takes a bribe for a pardon or an appointment, the president can't be criminally prosecuted. So I don't think it's possible from a textualist and originalist perspective to justify Trump versus the United States. It fits what I've said for a very long time, that the conservative justices follow originalism when it gets the conservative results they want, and they ignore originalism when it doesn't lead to the results they want.
Thank you. Somebody asked how the court's rulings in the last few years have changed how you teach constitutional law.
In one sense, what they've changed is just the subject matter, the doctrines. I still see my primary responsibility in teaching constitutional law to prepare the students to use the law in practice. Most of my students are going to be practicing in state courts or in federal district court and federal court of appeals. I want them to know the doctrines. I spend a lot more time teaching them about originalism because there are many originalist judges in the district court and courts of appeals. There's the majority of the court that's sympathetic to or adopts originalism. So they need to know how to make these arguments as lawyers. But overall, what I'm doing is trying to prepare them to be lawyers, and that task is no different. What has changed is I see many more of my students discouraged about the Supreme Court and about constitutional law than ever before. I've been teaching constitutional law since 1980. I'm starting my 45th year as a law professor. And I see more students who are discouraged about the Constitution, the Supreme Court than ever before. And I have to address that for them. And what I have to convince them of is that they still can use constitutional law for their clients, including in a progressive way in the lower courts. And that ultimately the message that I transmit and make explicit is Dr. Martin Luther King Jr. was right. The arc of the moral universe is long and it bends towards justice, but it will only bend towards justice if they work to make it happen.
Great. Okay, what do you think? One more question?
Sure.
Okay. We've got a lot of questions about Rahimi as well, so I'll throw one of those in. Okay.
Please.
Under Rahimi, what is the likely success of an argument that a felon in possession statute cannot constitutionally be applied to someone convicted of a non-violent felony? For example, bank fraud.
Right. The Ninth Circuit recently decided the Duarte case, and I think en banc review has just been granted in that, it's been vacated. But Duarte said that the federal law that prohibits felons from being in possession is unconstitutional if it is to a nonviolent crime. I think as to violent crimes, felon in possession laws, both federal and state, will be upheld because you've had an adjudication of somebody being dangerous. They've committed a violent crime. I think as to nonviolent crimes, it's unclear to me what the Supreme Court will do with regard to that in light of Rahimi. Now, there was a prior Ninth Circuit case before Duarte that had said such laws are constitutional. So I thought Duarte was inconsistent with circuit precedent. But what the Supreme Court will do with that issue, I don't think we can tell. I know we didn't get to all the questions. If there's some question we didn't get to that you want to ask me still, just send me an email and I'll do my best to get back to you. My email address you could use is just echemerinsky@berkeley.edu. And Whitney, thank you for posing the questions.
Thank you, Erwin. And I've also put his email address in the chat if anyone wants to snag that right now. Anything else from our wonderful alumni folks? All right, I think we're done.
And for all of you who watched, thank you so much. And thanks to our alumni office for arranging this.